This court unanimously allows her appeal and restores the order of Mr. Justice Moylan. The result is that her claims may now proceed to be determined afresh. We're driven to the conclusion that in this respect, the Court of Appeal's analysis was wrong. Lord Denning's criteria apply only when a litigant, unlike Mrs. Gohil, has already had a full opportunity to put forward evidence. Indeed, in saying that she could have proceeded to court in 2004 and could then have called evidence about Mr. Gohil's resources, the Court of Appeal forgot that the duty to set out his resources would have lain upon him rather than upon her. We conclude that Lord Denning's criteria are irrelevant to this situation. Mr. Gohil also argues that by that recital to the 2004 order, Mrs. Gohil accepted any risk that he hadn't made full disclosure. But his duty to make full disclosure was primarily to the court, and nothing said by Mrs. Gohil could absolve him from that. The recital has no legal effect. That is why we allow Mrs. Gohil's appeal, but we have had to think hard about whether to restore the judge's order or to direct that he should take a fresh decision whether to reopen the settlement. The complication is that in finding non-disclosure proved, the judge, through no fault of his own, relied heavily on evidence lifted from Mr. Gohil's criminal proceedings, which, in a separate appeal presented by the Crown Prosecution Service within weeks of his decision, the Court of Appeal held to have been inadmissible. We conclude, however, for reasons given in my judgment, but in particular in the concurring judgment of Lord Newburger, that in the light of the judge's findings upon the admissible evidence adduced by Mrs. Gohil, he would, by reference only to that evidence, again have found Mr. Gohil guilty of material non-disclosure, with the result that his order can properly be restored.